Hi, I'm Jesse David Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. Today, I'm going to talk about the top 3 clauses to include in your contract to help avoid litigation. But first, I'm going to say that if you have any questions about what you're about to hear today, you'd like to talk about your business, or you think of a potential case, all you have to do is go to meetjde.nyc. That's meetjde.nyc, and you can book a 10-minute phone or 30-minute in-person consultation. Now, what are the top 3 clauses I would include in a contract to help avoid litigation? The first one, I find this one to be the most important, is a mergers clause. Now, in New York, a specific mergers clause is extremely important, and I'll tell you why. Now, if you just do a general mergers clause, and I'm going to explain the mergers clause, I promise. But if you do a general mergers clause, it's not going to help you out in a lawsuit. But a specific mergers clause. Now, what is a mergers clause? A mergers clause basically says that it merges everything you've done to get to the point of the contract. Okay? So, any due diligence you've done, that you've consulted with attorneys, that you have done your own due diligence. The contract itself contains every part of the agreement. Now, the reason for this, and the reason you need a specific mergers clause that states all that, is a lot of times someone will try to bring a fraudulent inducement claim to get the contract thrown out. Now, a fraudulent inducement claim will fail 100% of the time if you have a specific merger clause in your contract. And again, that specific merger clause states that the contract contains everything that you guys have spoken about and agreed upon, and that nothing outside the contract survives. Okay? So if you said, I will pay 100 bars of gold if you sign this contract, and the contract itself says there's no outside deal, and there's no mention of 100 bars of gold, you will never get a fraudulent inducement claim to stick. That's the purpose of a merger clause, specific merger clause. Okay? This will protect you from a fraudulent inducement claim. So I find that one is the most important in helping you avoid litigation. Now the second one is any clause that specifies your damages, right? So if it says that if Joe Schmo breaks the contract with you, that they will owe a flat $30,000, okay? Doesn't matter, the circumstances per se, as long as they broke the contract, they're going to owe a flat $30,000. Something along those lines. When you have specific damages stated in a contract, okay, then you're not, as long as you can prove they broke the contract, you're going to be entitled to that $30,000. That prevents a lot of people from breaking the contract when they know exactly what it's going to cost them. Now, the third and final clause that I like to include, and it helps avoid litigation, is an attorney's fees clause. If you put in a clause that says the prevailing party in a lawsuit will be entitled to the costs, expenses, and attorney's fees, okay, then that clause alone lets them know that if they break this contract and they get sued and you win, that they're going to owe you your attorney's fees. And that could be as simple as $2,500 on a simple case to you could be talking about hundreds of thousands of dollars on a complicated one. So if they're going to lose, and they're going to lose a ton of money to pay your attorneys, that can prevent litigation. So again, I'm just going to say it, to conclude, the 3 contract clauses I like to include to help avoid litigation. The first one is the merger clause. The second one is a specific damages clause. And of course, it has to apply to the right type of case. And the third one is the prevailing party gets paid attorney's fees. And remember when you put that in though, that one can also bite you though if you're not the prevailing party. If you lose the lawsuit, you could end up paying their attorney's fees. So you still have to consult with an attorney and make sure that you want that clause in there. But those are the 3 clauses, like I said, that helps prevent litigation. So, if you like what you heard today, you want to talk more on it, you want to talk about your business, or you think you have a potential case, please go to meetjde.nyc, meetjde.nyc, to book a 10-minute phone or 30-minute in-person consultation. And if you like what you heard today and you want to hear more on how to protect your business, please like or subscribe, and depending on the medium, the one that works best. And remember, I'm Jesse David Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. Thanks for watching and listening.